How about if I get started?
Yeah,
I'm
absolutely.
just plugging my phone in again so it gets charged. Okay, so I'm going to start and I'm going to share my screen. We're going to start with the listing agreement. So give me a moment here. All right, there we go. Can everybody see it? We're all good? Okay. So as we go through, I'm just going to talk about the blanks. We're not going to go into depth about what it says. We're just going to talk about fill in the blanks. So as we go through, if you have questions about that, let me know. If you have questions about something I'm not talking about, let me know. But the reason I'm doing that, so it's not going to be like a super in-depth on the listing agreement. The reason is because we're going to do the contract next. Okay. So, and the same thing, we're going to look at the fill in the blanks. And if you have other questions about things as we go through, just let me know. Sound good? And just shout it out, because if you put it in the chat, I'm probably not going to see it. So I'm going to scroll down to the bottom first to show you this footer. Now, are you guys, I should have asked this first before I got this one. Are you a transaction broker office or a single agent office?
I think it's single agent, right?
Yeah.
Is it?
Yeah, that's what
Okay.
Murray was saying in the meeting the other day, that we aren't a transaction. We're one of the few that aren't transaction.
Okay. All right, then hold on. Let me get a different agreement for you.
We're actually an office that is allowed to be single agent.
Both.
Right.
Okay.
So we
All
are
right, then let me get a different agreement for you so we can talk about the differences, okay?
because let me tell you, Sally, one of the things we like for compliance is them to have that brokerage relationship form signed that
Okay.
says that they have permission to transition to a transaction broker.
Yeah, yeah. So I'm this one that I'm gonna get is the one that includes it. So that's the one I'm going to talk about, if that's okay. Okay, I apologize. I should have clarified this before I got set up, but it'll just take me a few more seconds here. All right, I'm almost there. Okay. So can everyone see this?
Yeah.
And you
Yes.
see the footer at the bottom, it says ERS, that's exclusive right of sale, because it's a listing agreement, right? And then it says -18, so that's the version that we're talking about. And then it says TN. That code is very important because the TN means that it contains the language to transition to transaction broker. And we'll talk about that when we get to paragraph 10. Now let's compare it with the other one that we have right here, which is, scroll down to the bottom, it says TB. So this is the transaction broker listing agreement. Okay, so they're going to be exactly the same until we get to paragraph 10. So I'm going to work off of this one and then we'll switch to the other one when we get to paragraph 10. Does that sound okay?
Sure.
All right. So here we are, our listing agreement. And the first thing is, who are the parties? And we're just going to remember, we're just looking at these lines over here with the asterisk, because the asterisk means there's a blank that needs to be filled in. So the first thing is, who's the seller? The best source of information for that is the deed. If you can take a look at the deed and see whose names are on there, that's good. The next best thing would be if you have a title policy. So the seller goes, yeah, here's my title policy. And you look and see who is named as the owners. You're going to use those names. Sometimes it might be a little tricky because lots of times, especially in our area with our population, the sellers pass away. And so they may still appear on the deed, but you need to do a little something different. And so in that instance, you would still want to put their name, and then you could say by, and then the name of their personal representative. So if, you know, Aunt Sue passes away and nephew Tom is the personal representative, then you would say Sue by Tom, her personal representative. Or, you know, sometimes you may have letters or orders from the court that would specify how it needs to be done. And so in that case, you would follow whatever the orders of the court are. Same thing with the power of attorney. Aunt Sue is away, and she has given nephew Tom authority to sign on her behalf. And so you would say Sue by Tom, her attorney in fact. Now, if it's a corporation or an LLC or something of that nature, then you would want to make sure that that entity is active and in good standing with SunBiz, the Secretary of State. So you just go onto the SunBiz website. Is everybody familiar with that? You can go onto the SunBiz website, which is the Florida Secretary of State, and you can do a name search for like Sue LLC, and it will tell you that Sue is active, and it will tell you who is able to sign, because it'll tell you who the members are or who the manager is. And that way you know that Sue individually can sign on behalf of Sue LLC. Same thing with the corporation. It'll tell you it's active, and it will also tell you who can sign, who is an officer or director who can sign on behalf of the corporation. Now, if it shows up that it's inactive or delinquent for some reason, that means that it is not legally entitled to transact business in Florida. And so it needs to get back into active status in order to be able to legally sign any documents. So that's an important step. If you don't catch it up front, title's going to catch it. And by then it could be very close to closing, and there may not be time to do what needs to be done. So if you just do a little due diligence up front, always a good idea. And that is actually a recommendation from the contract preparation manual that is put out by the Attorneys Fund and the Florida Bar, and Florida Realtors has a hand in it as well. So interestingly, I'm kind of like by default in charge of keeping track of the family businesses, and my son has an LLC up in Kansas, and I lost track of the renewal. It was supposed to be done last month, and I realized yesterday that I hadn't done it. So on the Secretary of State website, it was showing delinquent, inactive. I went on there, I filed the annual report, I paid the fee, and all is good. In Florida, just FYI, if you have an LLC or a PA or anything like that, the late filing fee is about $400. So you don't want to miss the deadlines in Florida. All right, next is the broker. And that doesn't mean Murray. That doesn't mean any individual person. It means the name of your brokerage. So Keller Williams Realty, Gold, or whatever the correct name of your brokerage is, that's what needs to go there. So it's not an individual name. It's not your name. It's the name of your brokerage. Does that make sense to everybody?
Yes.
Okay. Line 6. So this is in paragraph 1, authority to sell the property. And we want to say when the listing agreement begins. Now, ideally, the listing agreement is going to begin, the listing period is going to begin when everyone signs the agreement. So if everybody's signing today, May 4th, may the 4th be with you, right? Sorry, I had to say it. Then you can put May 4th right there. Sometimes people put a date in the future, right? Because it's like, well, the seller wants to get things ready, and we're gonna put it in later and all that kind of stuff. Don't do that, because technically you don't have an effective agreement until the listing period begins. And there actually have been instances where the other listing agent swoops in and gets the listing away because it hasn't yet started, because they signed it to start 2 weeks later or a month later. So if you're gonna actually make it active at some point in the future, use the exclusion forms. That's what they're there for, right? That way you have an active, valid listing agreement, and the MLS listing will be active at a later date. So don't, especially in this market where people are like scrambling like crazy, don't let that happen to you. On that same line, we need the termination date. This is a statutory requirement, and failure to put this in could subject an agent to fines. It is a finable offense if you don't have a termination date in there. So you want to make sure you put the termination date. I love this one. It is at line 8. Seller and broker acknowledge that this agreement does not guarantee a sale. If only it did, right? Well, in this market, it kind of does, but not always. And then at line 11, seller certifies and represents that he, she, it is legally entitled to convey the property and all improvements. That's just saying, yeah, I own it and I have authority to sell it. So that would be an important consideration for a trust, right? I had some conversations with another brokerage last week about what do we do for a trust. Well, the recommendation has always been get a copy of the trust. 2 reasons. You want to make sure that the trust itself is authorized to buy, sell, own, convey real property. And you also want to make sure you're working with a trustee who is authorized to sign on behalf of the trust. So 2 very important things. People are reluctant to disclose their trust. And so that's why we have certifications of trust, or we have a redacted version that just set out those basic powers. And they also indicate who is authorized to sign on behalf of the trust. You can ask for it. Sometimes they're reluctant to reveal it. If they are, just let them know title's probably going to want to see it. So they need to get ready. And honestly, anybody who does business with a trust should be asking for that. That should be something that they readily provide, although a lot of people are not sophisticated enough perhaps to know that they need to be ready to do it. Paragraph 2. Okay. So this is the description of the property. Super important, perhaps not quite so important with a listing agreement as it is with the contract, but it's still important nonetheless. Because a contract that involves real estate may not be valid if the legal description is incorrect. So legal description is an essential term of the contract. You want to make sure you have it right. So I'm looking at line 15 that says legal description. This is the star of the show, right? You have to have the legal description and you have to have it right. So my suggestion is copy and paste. Even if it's a very short legal description, don't try to type it in because it's so easy to make a typo, an error, and it's very hard to see our own errors, right? We always see typos that somebody else made. It's hard for us to see our own. And so don't take a chance, copy and paste. Same with the names of the sellers. Best source is the deed. Next best would be the title policy. And then after that, you can look at like public records, like the tax assessor and those kinds of things. And now let's go back up to line 13 where it asks for the address. The address is like the supporting actor. That's the role of the address. It helps to provide clarity so that we know which one we're talking about. Because if you showed me the legal description for my own house, I wouldn't recognize it probably. I would go, it might be because I recognize the neighborhood, right? But I wouldn't necessarily recognize it by the legal description. it's easier for us to refer to something by the property address. And so that's why we have it there. It's for clarity and convenience. Now you'll notice at line 16, it says see attachment. That's what you would do if the legal description is too long to fit there on lines 15 and 16. You can always put overflow in paragraph 14, additional terms, but I've seen legal descriptions that are pages and pages and pages long. And obviously you're not going to get it in this listing agreement, right? So you would just say, see attachment. And then I would even say exhibit A or exhibit 1 or whatever you've called it, so that you've clearly identified the attachment. Does that make sense? All right. And then at paragraph B, we're going to say personal property, including appliances. So at this point, my suggestion is show the seller the contract. So let's look at the contract right here. Okay. Show them paragraph D right here, where we talk about the personal property that is included in the contract, and say, this is everything that's going to convey. Is there anything on this list that you do not want to be included? Ask them, let them see it. Don't let them be surprised by it. Because look at line 17, it says ranges, ovens, refrigerators, plural. So the refrigerator in the kitchen and the refrigerator in the garage, refrigerators, let them know everything that's going to get included. It seemed like for a while there was a lot of controversy around draperies. At line 18, draperies. Does everybody know that draperies and curtains are the same thing?
Yes.
Apparently some people don't. So congratulations. Some people did not realize that curtains are the same as draperies for most people, because the buyers showed up after closing and go, where the draperies?
Curtains.
And they call up the seller, and the seller goes, well, we just took the curtains. Like, what? They're heirloom curtains and you just couldn't part with them because you thought curtains were different from draperies. So clarify all that up front. That's all I'm saying, right? And this is the point where you have the declutter conversation. So, I love the garden gnome collection, and I know you can't bear to part with Elvis, the garden gnome. So let's pack him up now so that nobody thinks that Elvis gets included with the sale. And imagine how sad you would be if somebody came and something happened to this particular garden gnome. So same with the China doll collection, right? The porcelain dolls that are all creepy with the eyes in the closets. Pack them up. They're beautiful, and we don't want anything to happen to them. You're moving anyway, right? So you want to put it to their advantage. I understand how valuable this is to you. It's going to be valuable to somebody else too. And honestly, they're going to probably want to buy it. They're going to want to include it. And if you don't want it included, let's go ahead and pack it up now. Same with the special light fixture that Great Aunt Martha gave them for their wedding. Take it out now, put something in that you got at Home Depot, something that you don't mind parting with, and that way it never comes into play. So those kinds of things, this is the time to have that conversation as you're going through the listing agreement with the seller. You would also want to think about specifically saying things that are not included, like Great Aunt Martha's chandelier, right? And you would want to put that maybe at line 18, you could say, see paragraph 14, additional terms, or you could check it where it says see attachment. But I would specifically mention everything that is going to be included and everything that is going to be excluded, and keep track of it and make sure that it's reflected in your MLS remarks. Make sure it's reflected on the contract, because the contract rules. So if the washer and dryer are not going to be included, make sure you know that, make sure it's in the MLS, and make sure it's on the contract. There was an agent, a very experienced agent, who had to buy a washer and dryer because it was in the MLS that it was going to be included if the buyer wanted it, but it did not get carried over to the contract. And then the seller decided they wanted it after all. Guess what? The seller kept it and the agent got to buy a new one for the buyer. At paragraph C, we're talking about occupancy, and this is tenant occupancy. So it says property is or is not currently occupied by a tenant. If occupied, the lease term expires. So this is when you want, again, to refer to the contract. You see, you're preparing your seller for when they're going to get the offer, and you're showing them the things that are in this listing agreement that correspond to something in the contract. And you're going to look super smart, and they're going to love you because you have prepared them in advance. And so here's what you're going to prepare them for. So seller, it is occupied by tenants and the lease term expires next February, which is going to be long after closing, right? The way things are closing nowadays. So seller, let's look at what the contract says about that circumstance. So let's look at paragraph 6B, where it says, if the property is subject to lease or occupancy after closing. And it says that if that's the case, the seller needs to provide copies of the lease to the buyer within 5 days after the effective date. So imagine how much the seller is going to appreciate if you tell them at your listing appointment, go ahead and get copies of those leases all together, gather them up, because as soon as we get the offer, we're going to need to provide copies to the buyer within 5 days after the effective date, right? You're doing them a favor. You're telling them, be prepared. This is what we want to do. So remember that. And again, they will think you're amazingly intelligent. And you are, right? Paragraph 3, we're talking about price and terms. At paragraph A, it says the price. This is another one of those statutory terms. It says failure to put the price in could be a reason to get a fine. So you want to make sure you put the price. And here's, in my understanding of the process, here's how I see it happening. You want to, agents typically pre-fill as much as they can. So all of that stuff we've just talked about, probably it's going to be filled in for the most part, you know, certainly the names, the legal description, the address, all that kind of stuff. The price is something that you talk about at the listing appointment, right? And you may present them a range of values, and then it's up to the seller to decide. And so everybody decides on what the price is. And, you know, there's so much else going on. Sometimes the agents forget to fill in that blank. And so that's how it can sometimes be left blank. But you want to make sure you go back and put it in, because it is a statutory term and you can be subject to fine if it's not there. These next ones are things that you want to talk about and refer the seller to perhaps a lending partner that you have if they want more information. And by checking these things, it doesn't mean that they're obligated to accept an offer that includes these. It's just that they might consider. So all of this, the seller is not obligating themselves to any of these terms. It's just saying that they might consider, right? Ultimately, it's up to them to consider and accept any offer that they want on any terms that they find acceptable. The first one is financing. Is the seller willing to offer or consider seller financing? If so, what would that look like? And you don't suggest any of these terms to them. These are things that they would give to you, because if you start negotiating terms, if they start asking you, well, what do you think? What do you think? You don't think anything about it, because that would potentially put you in the role of a mortgage loan originator. And if you're not licensed to do that, that's a problem. You just want to talk to them about it. maybe their loan is assumable. With the low interest rates, it doesn't make sense. Probably not going to see many assumptions, but you might. And I just realized that I skipped at line 23. So cash, conventional, VA, FHA, right? So any of those, certainly you can provide basic information about it, but if they start asking a lot of specifics about, well, how does this work? What would that be? You might want to get some materials that a lending partner could provide for you. All right, seller expenses. So again, this is not obligating the seller to pay any expenses on behalf of the buyer. It's just saying that maybe they would consider. And if they would consider, how much would it be? And so it asks at line 37, what percentage of the purchase price, right? And so you let them think about it. Would they be willing to do that? Probably not in this market, because they may not have to, right? All right, any questions about that before we move on? No. On each page, you're going to want everybody to initial. So seller right here, you on behalf of the brokerage should initial right there. So in a standard format listing agreement like this, you are authorized to sign, initial, all that kind of stuff on behalf of the brokerage. So you wouldn't have to get Murray or somebody else, an officer, director, member to sign on behalf of the brokerage. You can do it. Okay. So again, we're doing all the flyover stuff. We're just talking about the fill in the blanks. And our next potential one is right here at line 60. So this is talking about not publicly marketing. Celebrities probably don't want you to publicly market, right? Sometimes people in law enforcement, like police officers, prosecuting attorneys, people like that, or sometimes survivors of domestic abuse, those kinds of things. They don't want their information out there. And so they would say, I do not want it to be marketed publicly. And so they would check there. Right here at line 60, seller does not authorize broker to display on the MLS. And if that's the case, then you would want to make sure you use the market exclusive forms so that you could still file with MLS. Oh, and I guess I missed another one at line 58, display the property on the internet except for the street address. Same thing, same principles. Some of those categories of people may not want the street address to be displayed. There are other people who may not want the street address displayed, right? Because they want to discourage people from just driving by and curiosity, that kind of stuff. At line 65, we're going to ask for the initials of the seller just to make sure they understand all of this. What are the implications if we're not marketing publicly? And it talks about all of this. If we check that box up there, then we're not going to put a for sale sign out, right? We're going to be limited to marketing it within the office. So, if you're out to lunch with somebody from another brokerage, you can't talk about it. You can't even hint about, you can only market to people within your own brokerage, because anything beyond your brokerage is going to be publicly marketing. At paragraph E, these are things that you're going to want the seller to, you're going to check on behalf of the seller if it's okay. And the first one is to use a lockbox. Almost always, people use a lockbox, so you can provide easy access to other agents to bring buyers to show the property. At line 72, so this is a little bit controversial, but here's my thinking on it. The first one is withhold verbal offers. So some people think, well, if I get a verbal offers are, famously worth the paper they're written on, right? And so why would you get the hopes of the seller up if all you have is a verbal offer, right? My thinking is tell them. Because what if they already have an offer and they're like, I'm not really happy with this one. The fact that there's a verbal offer out there that could soon materialize into a written offer might affect how they analyze the offer that's in their hands, right? And especially in this market, because it's so fast, you might want to let them know. Even if they say, don't tell me, you might want to say, look, I know you told me not to tell you. However, and then tell them, and then they can do what they want with the information. Because if they find out, and they will, then, and if they're not happy with what they got, and the other one always looks better, right? There could be some friction there. Same concept with the next one. Withhold all offers once the seller accepts a sales contract. Even if they tell you, don't tell me if something else comes in, tell them anyway, right? Because everybody's always interested in a backup. So same thing, I would tell them, look, I know you told me not to tell you. However, we have this offer that just came in. Again, that could influence their decisions on the repair list that the buyer just sent in, and you know, still within the inspection period. If there's a good offer that has come in better than the one that's already there, that's going to influence how the seller negotiates on that repair list, right? It's going to influence how they negotiate on everything in that contract. So
Do they have to check one of those? I mean, is that a mandatory thing with that being an asterisk?
No, they only check it if they're saying, don't tell me about verbal offers. Don't tell me about offers that come in after we have an effective contract.
Okay.
So typically those would not be checked. And again, my thinking is, even if they are checked, tell them anyway.
Okay.
The next one has to do with how we syndicate the information out, the virtual office websites, right? It gets put out on Keller Williams, it gets put out on everything, all the IDX feeds that everybody picks up. And that's what this is all about. So at line 80, it says seller does not authorize the automated estimate. So that's like the Zestimate. And then line 82, seller does not authorize third-party comments or reviews about the property. So if that's the case, you want to make sure those are checked. And then that should be reflected in how the IDX feed goes out from MLS. Paragraph 7, these are the seller's obligations. And I'm not going to go through these again because of the format of the class, but I just want to bring a couple of things to your attention. At line 91, inform broker before leasing, mortgaging, or otherwise encumbering the property. So very experienced agent a few years ago was telling me, you know, I always have that conversation with the buyers. Once you are approved for a loan and you have an effective contract, do not do anything that could potentially affect your credit, right? Don't go out to dinner. Don't use your credit cards. Certainly don't go on the vacation and celebrate, and don't buy a new car, and don't, you know, that kind of stuff. And she said, I never thought to have the same conversation with the sellers. And what happened was, after the contract was effective, the sellers went out and got a home equity line of credit, and they used it. And I was like, well, there goes the net sheet, right? So, and she didn't find out until afterwards. What this says at line 91 is, tell the broker before you do any of that stuff. So just to bring that to your attention. And then the next one at line 98 is Ferpta issues. You know, that they need to tell you up front, look, I think I'm subject to Ferpta. And then you can send them off to talk to the experts. 3 or 4 years ago, an agent called me up the day before closing. The seller just told me that Ferpta. I'm like, what? You just now found out? Are you crazy? And the agent was on the IRS website working through the regulations, trying to make a decision about Ferpta. No, that is not the way to do it. The agent certainly should not be making that determination. So if that's the case, then you want to know upfront. And so as you discuss this with them, you can ask them, does this apply to you? And then you know how to proceed.
Can
At
you tell
line
me
10,
what Ferpta is?
this is for foreign persons, and it has to do with tax withholdings on the sale proceeds.
Okay, thank you.
Yes, sorry. If I talk in acronyms or something that don't make sense to you, let me know, please. And we'll talk about it again when we get to the contract. At line 102 in paragraph G, we're talking about disclosures. This is the Johnson v. Davis disclosure, right? Because it says facts that materially affect the value of the property that are not readily observable or known by the buyer. So Johnson v. Davis, that's exactly what that is. And it says that there are none of those things except, and then they can write it at line 102. I don't think I've ever seen anybody write anything at line 102. Typically that stuff is going to go in the seller's property disclosure, right? And here's a key. There's another case after Johnson v. Davis, and you all know this. It extended that disclosure requirement to real estate licensees. So if they disclose here, and or if they disclose on the seller's property disclosure, guess what? Now you know, and you have a duty to disclose if they don't. And I've had conversations with agents who are like, well, the seller, blah, blah, blah. And now we know, and the seller doesn't want to disclose. And I'm like, well, guess what? You have a duty to disclose. So when you know about, and you can't pretend ignorance. I know there's some people who have a policy of, if the buyer sends them the inspection report, they won't open the email. Well, studied ignorance is not an excuse. So if you know, you know, and you have to disclose. All right, moving on. Any questions about this page before we move on? So this is the fun part, paragraphs 8 and 9, because this is where you get paid and everybody likes that, right? So let's talk in general about how paragraphs 8 and 9 work, because I've seen this wrong in a lot of instances. Paragraph 8 is your total commission that you and the buyer's agent are going to share. Okay. Paragraph 8 is the total commission. It's not just your part. Paragraph 9 is the commission that is going to be paid to the buyer's agent. So paragraph 8 minus paragraph 9 equals what you keep. Does that make sense? So many times I've seen, and here's the thinking, I'm making up numbers because we don't talk about commission, right? I'm gonna get 3% and the buyer's agent is gonna get 3%. So paragraph 8, line 109, 3%. Paragraph 9, line 133, 3%. Guess what you get as the listing agent? Big fat 0, right? Because paragraph 8 minus paragraph 9 is what you keep. And there have been some astute sellers and some less astute real estate agents. And guess what the agent got? 0. Because they put 3 and 3, and the seller didn't say anything. Nobody said anything. And they got to the closing table and their commission check was 0. So don't be that agent. And you want to make sure you fill in everything here. So paragraph A is when you sell the property, when a buyer comes and they buy the property and that's it, right? And you can also add in transaction fees. If your office has a transaction fee of $199 or $399 or whatever it is, you can add that there because it says blank % of the purchase price plus, and you can put that there. And then it says or, and the or could be a flat fee. Sometimes if it's a low dollar listing, people will put a flat fee, right? So you can put the flat fee there in that other blank on line 109. Paragraph B, this is for an option. So let's say buyer comes and says, gee, I really like the property. I think I might want to buy it. I'm not sure. So I'm going to pay you an option fee. So I'm going to have 6 months to think about whether I want to buy it. And within that 6-month period, I can exercise the option, right? So they're going to pay an option fee to the seller to kind of hold it off exclusive to that person. And the option fee might be $10,000. So you want to get a sizable chunk of that option fee, right? With the understanding that when the buyer exercises the option and actually buys the property, that option fee is going to be credited against your total commission. That's what it says. So you might want to put 10% there. I'm just making up numbers. But if the option fee is $10,000, you might want to get 10% of that. So your part of the option fee would be $1,000, right? Paragraph C is if it's not a sale, it's a rental. You know, the seller comes in or the buyer comes in and goes, gosh, I really love the house. I can't buy it right now, but I really want to rent it. Is that okay? And the seller goes, yeah, sure, I'll let you do a lease. So you want to get a portion of that, and you want to make it make sense in terms of what that means, right? So if you look at line 115, it says a dollar amount or a percentage of the gross lease value as a leasing fee. So the gross lease value would be over the life of the lease, right? So let's say it's $1,000 a month for a year. So that's $12,000, right? So you wouldn't want to get 3% of that, right? You want to make it make sense. So maybe you would get 10% of that, or maybe you would get the equivalent of 1 month's rent. So you can structure it however it makes sense for you, but just think about the different types of transactions that you're talking about here and what makes sense in terms of a reasonable commission that you would get on that type of transaction. All right, in paragraph D, we're talking about the broker's fee and when it's due. The fill in the blank is at line 122. And this is your protection period. So what this says is during the listing period and for X number of days afterwards, if any buyer who came during the listing period later says, I'm going to buy the property, and they do buy the property, then you would be entitled to commission, so long as they haven't already listed with another broker. And so some people put 90 days, some people put 30 days, some people put, I've seen it 365 days. I've seen it a year. Can you imagine a year protection period? People were doing that 3 or 4 years ago. It made no sense, but nevertheless, that's what they were doing. So here's the scenario. You're 2 days before the end of the listing period, and the buyer comes and goes, oh, I love this house, but gosh, it's expensive. And for some reason, you're not there. The other agent isn't there. It's just the seller and the buyer talking, and the seller goes, well, you know, my listing agreement expires in 2 days. Why don't you come back in 3 days and I'll cut you a deal because I don't have to pay commission, right? You would be able to claim commission on that transaction because the buyer came during the listing period and bought within the protection period. Line 127, retained deposits. So this says that if you're in a situation where there's an effective contract and for some reason the buyer terminates and the seller keeps the escrow deposit, then you would be entitled to 50% of the escrow deposit. It defaults to that. You can put whatever percentage you want. Now, some agents say, oh, I just put 0 there. But think about it. If sometimes transactions fall apart at the end, and it's really at the end when all the work is done that the seller would be more likely to be entitled to the escrow, right? Because the buyer can terminate for any reason within the inspection period and keep the escrow. The buyer can terminate within the loan approval period and keep the escrow. So if we get to the point where the seller would be entitled, we're probably really close to closing, and you've done a lot of work. Why wouldn't you keep part of that escrow deposit for yourself? It's a business decision for you to make, but just think about what that looks like in real life. All right, paragraph 9, this is where you put how much you're going to pay to the buyer's agent. And there are 3 possibilities here. The first one is a single agent at line 133. And you can put a percentage or you can put a flat fee. And sometimes agents put a percentage or a flat fee minus a transaction fee. So they charge the transaction fee back to the buyer's agent. Up to you what you do and what your office policy is. The next option is transaction broker. How much would you pay to a transaction broker? And then the third option is an agent who has a no broker relationship with the buyer or the seller, which means they're just passing the paperwork. They're not really doing anything. Some market centers have a policy that all 3 of those need to be the same. So if you're paying 3 to 1, you have to pay 3 to all. Some of them leave it up to the agent to decide how much they would pay each type of agent in each particular relationship.
So can we look at 115 again? If you leave that blank, so if you have a contract and say you have a home, if you didn't fill out that part where it says the lease, then you could not get anything. As long as you have that filled out though, and that whole deal turned to a lease, then you're good to go.
Yes, yes. So I have seen some where the agent didn't fill it out because they're like, oh, we're just doing a sale. Well, things change, right? So you want to make sure you've protected yourself for anything that could happen with the transaction.
Thank you.
Yes, you're welcome. So here we are with the broker relationship. This one, remember, is the transaction broker, and it lists all of the duties of a transaction broker. So if you remember from your pre-licensing class, we have certain duties, and those duties are based on the type of relationship. So in a transaction broker relationship, it's not a fiduciary relationship. And so you have certain duties, and then there are duties that are common to all of the relationships. ADD, we all have ADD, account for all funds, deal honestly and fairly, and disclose all known material facts. It's the Johnson v. Davis duty. And then there are other duties that are specific to the transaction broker, and they're listed there in paragraph 10. Now let's look at the single agent duties. So paragraph 10 here looks very different, right? So when you're a single agent in a residential transaction, you must give written disclosures of the duties. And so this is included in this listing agreement. So here we go, all of the single agent duties. You're going to put the name of the sellers here. Oh, I'm sorry, no. You're going to put the name of the brokerage here. So as a single agent, in the name of the brokerage and its associates, right? So it's not only you as the agent, but it's everybody in the brokerage. So this is important. If you're acting as a single agent and you do not have consent to transition, nobody else in your office can even show that property. That's important. Nobody else can even show it. So if you're acting as a single agent, you always want to make sure you get this consent to transition as soon as possible. And ideally, it's because you've used this listing agreement and it's included. The statute says that you must get signatures immediately following the disclosure. So that's why you have a set of signature blocks here. The sellers must sign. Now, the next part of the statutory, and this is right out of the statute, the next part of the statutory disclosure is you must disclose what consent to transaction broker means, and you must disclose the duties of the transaction broker. So that's what this second part is all about. And you're going to put the name of the broker here again, right? And now it lists all of the duties of the transaction broker. And again, right out of the statute, they must sign immediately following that consent to transition to transaction broker disclosure. So those are the brokerage disclosures that we were talking about earlier. There are separate disclosures that can be used, but if you're using this listing agreement, you don't need the standalone disclosures. Does that make sense? And the statute says that you must get these disclosures signed, so you have to give them and get them signed immediately within the initial listing agreement or buyer brokerage agreement if you're on the buyer side, or certainly before showing the property. So the sooner you get these disclosures given and signed, the better off you are. Okay, now we pick back up with this because everything else is the same in each of the agreements. Conditional termination. So sometimes seller wants to terminate, their plans change, or whatever happens, right? You can charge a cancellation fee, and some people do that. This is at line 144. Some agents say, oh, I never charge a cancellation fee. Some agents say, I always charge a cancellation fee. Sometimes it's a deterrent to the seller to cancel the agreement when they say, we want to cancel, and the agent goes, okay, I'm happy to cancel, $5,000 cancellation fee. And the seller goes, maybe not. And I know of instances where they have not canceled because they didn't want to pay the fee, and later they had a contract and the property was sold, so everybody was happy. I've known of other instances where they actually paid the fee. So again, business decision on what you want to put there. At line 154, we're in paragraph 12, dispute resolution. So this says arbitration, and in dispute resolution, typically we mediate, right? That means we play nice, and we try to resolve any disputes between ourselves. Sometimes people say, no, I don't want to do that. I want a third-party arbitrator to come in and decide for us. If that's the case, then everybody needs to initial at line 154. It's voluntary. It's not mandatory. You do not have to agree to arbitrate. So some people have said, oh, but you have to. No, you don't. It's voluntary. You can agree to do it, or you can not agree to do it. If you agree to do it, then everybody initials. If you don't, then nobody initials. Okay, miscellaneous. This is just, kind of like the catch-all about, yeah, we can do electronic signatures, we can do whatever. Additional terms. So this is where you're going to put overflow stuff. If the legal description is too long and it's not going to justify having an attachment, but it's more than will fit in those lines, you can put it here. Property that is included or excluded, you can put it here. Here's another thing you can put. So think back to paragraphs 8 and 9, where you talk about the commission that you're going to get, the commission that the buyer's agent is going to get. Sometimes agents say, and if I bring the buyer, then the commission is, the total commission is going to be 5% rather than 6%. Has anybody had a transaction like that, or have you heard about transactions like that? So we call that a variable rate commission. And you can put that in paragraph 14. And the thing to understand about the variable rate commission is in the MLS, there's a special place where you have to disclose that. You don't have to disclose your total commission. You only have to disclose the differential. So if total commission is 6%, but this says, and if I bring the buyer, it's 5%, the differential is 1%, right? And I need to disclose that if the buyer's agent asks me what's the differential, I need to say 1%. Why is that? Because it levels the playing field. If the seller is considering two competing offers and one is from me as the listing agent and the seller is going to pay less commission, and it's from a different agent representing a different buyer, which one do you think they're going to choose, all things being equal? Probably mine, because they pay less commission, right? So ultimately they net more. So we want that other buyer to know that so that they can sweeten the pot and be competitive with the offer that I'm bringing. So that's why we disclose the differential. And then we want all the signatures. Everybody signs. So remember, in the other listing agreement we looked at, you're going to have 3 sets of seller signatures. You're going to have one set after the single agent duties. You're going to have one set after the consent to transition to transaction broker. And then you're going to have one set at the end where everybody signs. So everybody signs, all the sellers. If you need to add more signature blocks, do it. If you need to add another page for signature blocks, do it. Everyone who is named on the deed needs to sign the listing agreement. Unless, and I had this recently, there were like 5 or 6 sellers. One seller had power of attorney for each of them. However, that person needed to sign that many times because they have to sign on behalf of each seller, right? So it was Tom by Fred, his attorney in fact, Susan by Fred, her attorney in fact, and you just go through the list. So even if one person has the power of attorney, they still have to sign that many times because they have to sign on behalf of each seller. The last one on here is line 191, and this is a statutory requirement. It says copy returned to seller on, and you're going to put the date, and then you're going to indicate how it was returned, because the statute says that you have 24 hours to return a fully signed agreement to the seller. 24 hours. So that's why we want to know the date, because if we got audited, they would look at the dates of the signatures and they would look at the date of this, the return date, and then they would see how it was done. So you want to make sure that gets filled out. Now, most people take the position that if everything is done electronically, you don't need to fill that out separately because the electronic thing happens kind of simultaneously, right? As soon as it's signed, everybody gets the completed version of it. It would only really apply and be very important if you're getting actual signatures. Then you would want to make sure you get it returned to them within the 24 hours, and you want to indicate how you did it. Okay, and we are at the end of the listing agreement. Does that make sense to everyone? Any questions before we move on? Good. Anybody want to stand up for a minute, have a break, or we're good to go? Okay, so I took up way too much time on that, so I apologize. We're going to have to really speed through the contract. And if I don't get to cover everything, then we'll do this again. How does that sound? But some of the things we've already talked about, so we won't need to belabor them. Lines 1 and 2, we're talking about the parties, the seller and the buyer. Same concepts that we talked about in the listing agreement, right? Same sources of information, the same things if it's an entity like an LLC, a corporation, all of that stuff. Paragraph 1, same concepts with the street address. The street address is the supporting actor. The legal description is the star of the show. And then you see that it says, including all the appliances, etc. And you've already called the seller's attention to that when you did your listing appointment. So there are no surprises there. You want to call the buyer's attention to this if you're working with the buyer. Paragraph D is personal property. We've already looked at what that includes, right? And if there's anything on that list that is not already in the contract that will be included, like the washer and dryer, then you want to put it at lines 20 and 21. If there's overflow for any of these things, like the legal description or the personal property, or paragraph E, the property that is excluded, like the Elvis Garden Gnome or Great Aunt Martha's Chandelier, then you're going to put it there. Overflow goes in paragraph 20, additional terms. If 20 is not sufficient, then you can do an attachment. And on these lines, you would say see attached, exhibit, and whatever you've named it, so that it's clear what attachment you're referring to. Purchase price, you want to make sure you put the purchase price in there, right? And the amount of your escrow deposit. At line 29, it says that it either accompanies the offer. I've never seen that happen. Don't do that. Doesn't make sense. Or it's to be made within X number of days after the effective date. And the default is 3 days. We count calendar days in this contract. So it's going to be calendar days, but remember how we count time. If it ends on a Saturday, Sunday, national legal holiday, we move forward to the next business day at 5 p.m. Lines 32, 33, 34, statutory requirements. You must fill in the name of the agent who is holding escrow, whether it's a title company or a closing attorney, whoever it is, you want to fill that information in. That's part of our duty to account for all funds. And it is a finable offense if it's left blank or you put anything else like seller's choice, TBD, anything like that. That's not going to work. You must fill in the information. And where it says the name, it's not the name of your contact. It's not Susie at the title company. It's the name of the title company. And then we want to know the address, because there are probably lots of locations for Stewart Title, right? We want to know exactly which one it is. And then the phone and the email. Nobody uses fax. Does anybody use fax? No. Additional deposit, sometimes that's negotiated for. If it is, fill in the blank. Paragraph C is financing, and you notice it says express as a dollar amount or a percentage, so you can do it either way. And then it says see paragraph 8. Paragraph 8 talks about financing. We'll get to that in a minute. D is other. So I always wondered about other. This could be like if it's a 1031 exchange, you could put that in there, right? So you could put the address of the property and the value, because that would be part of the compensation. If it's the RV or the boat or stocks or, you know, Bitcoin, whatever it is that's going to be included to help pay for the purchase price, you could put that at other. And then E, balance to close. People sometimes write balance to close. Well, that's not responsive. Do the math, just write the numbers. And I get why people don't want to do it, because what if the purchase price changes? What if some of those other figures change and you have to redo it and it's messy? Make it messy. It doesn't matter. It's better to put the actual amount, because that's what the contract calls for, than to put balance to close.
I have a question before you go on. Is
Yeah.
this says as is contract, so is it the same as a standard?
No, it is not. All of this stuff that we've talked about so far, it's exactly the same as in the standard contract.
Okay.
Yeah. The differences are, and I did a class, I can't remember now when it was, probably a couple of months ago, on the differences between the as is and the standard. And they have to do mostly with paragraph 9 and paragraph 12.
I was in that class, so I remember, yeah.
Oh, okay, good. Line 45, this is the time for the acceptance of the offer. So you can tell them, look, you have until tomorrow at 5 p.m. to get back to me on this. And if they get back to you at 5:01, guess what? You don't have to play. Once the time for acceptance has passed, the offer is dead, and the buyer is no longer obligated to deal with the seller. In real life, it happens, but it's totally up to the buyer. And then you're going to specify the closing date, right? And we did the critical dates class last week for the forum, if anyone was on that. when we talked about how to calculate all this to make it make sense in terms of all of the time periods that need to happen in the contract. Each page, everybody initials, buyers and sellers, right? Okay, we already talked about paragraph 6. At line 68, you're going to check that box only if it's tenant occupied post closing or seller occupied post closing. So those are the only 2 instances where you would check B. Paragraph 7, we're talking about assignability. This comes up quite a lot. The first option is the buyer may assign and be released. So the new buyer steps into the shoes of the old buyer goes away. The next one is may assign but not be released. So buyer assigns, new buyer comes in, old buyer still there. They're both jointly liable under the contract. And the last option is may not assign. So this could come up a lot because sometimes the buyer is like, oh, I may want to take title in the trust, or I may want to take title in my LLC, or whatever. So it's a related entity, or sometimes they do it to assign it to some third party. So and if it's a 1031 exchange, it must be assignable because there's a third party intermediary who needs to be involved in the transaction. Paragraph 8 is our financing. First one is paragraph A. It says cash, but cash doesn't mean cash. Cash just means that there is no financing contingency. The buyer could still go get a loan. It's just that the transaction is not contingent on that. So whether the buyer gets the loan or not, the buyer is still obligated to perform. Paragraph B is the financing contingency. And you're going to indicate the type of financing here: conventional, FHA, VA, other. That could be like USDA loan. And then within blank days, this is our loan approval period, and the default is 30. The next one is we're going to talk about some of the basic terms of the loan. Is it fixed or adjustable? What's the initial interest rate, not to exceed, all that kind of stuff. And what's the term? The next one at line 91 is when is the buyer going to apply for the loan? And it says within 5 days after the effective date. That's the default. We can put another time period in there if we want to. Okay, I'm skipping all of this stuff about the financing because there are no blanks, but I do other classes where we go into depth on this. So if anyone has specific questions about that, feel free to contact me later and let me know, and I'm happy to talk about it. Or we'll set up another class and do it. Line 123, this is assumption of the mortgage, and there's a special addendum that goes with that. Line 124 is, it says purchase money note. This is seller financing, and there's a special addendum that goes with that. So you want to make sure you use all of the right riders that go with these special circumstances. Paragraph 9, we're talking about closing costs, and the first one is closing costs to be paid by seller. The line here is at line 131 where it says other. If seller is willing to pay closing costs on behalf of the buyer, that's where you would put it. You might also say, see paragraph 20 additional terms if you feel like there's not enough space to write it out there. If there is none, put NA. Don't leave a blank, because I've heard heartbreaking stories of where some other agent filled in the blank and the listing agent didn't catch it, and suddenly the seller was obligated to pay closing costs. So even if you're not doing anything, fill it in. Just put a line, or put NA, whatever the case may be. That way, if someone tries to change it, it'll be obvious that somebody tried to change it. Line 144, so this would be other, closing costs to be paid by buyer. Maybe they're paying something on behalf of the seller. Maybe they're paying the documentary stamp tax on the deed. That happens. I've seen that recently. Paragraph C, we're talking about the title evidence. So the blank says if it's a finance transaction, it's at least 15 days prior to closing. If it's a cash transaction, it's at least 5 days prior to closing. This is the time period when the buyer is going to get title evidence. And that title evidence is the commitment plus legible copies of everything that is going to be an exception on the commitment. Lines 158 and 162, this is who gets to choose the closing agent. And the basic rule is whoever pays, oh, I'm so sorry. I thought I shut my phone off. I apologize. So whoever pays gets to choose, right? So if the seller wants to choose the closing agent, then they are going to pay for the owner's policy. So you would check line 158. If the buyer wants to choose the closing agent, then they get to pay for the title policy, and you would check line 162. And there are instances when each of them might want to be in charge of that, right? I've seen cases where they actually are not truly fighting, but they're kind of like back and forth about, no, I want to pay, I want to choose, no, I want to choose. So it really is up to the buyers and the sellers to negotiate that. And whoever wants to choose gets to pay. And just give me a moment while I silence my phone. I apologize. I thought I'd done it. All right. Questions about this? Line 164 doesn't apply to us because this is only for Miami-Dade Broward area. Our next one is paragraph E, where we talk about home warranty. So this is either buyer pays, seller pays, or nobody pays because we're not getting a home warranty. And then we want to specify the company, whoever the home warranty company is, and the amount. So the hint here is make sure that amount is sufficient to cover the amount of the policy. I've seen instances where the amount was not sufficient to cover the policy and the title company didn't know what to do with it. And so nothing happened with it, right? They tried to send it to the warranty company. The warranty company said, that's not enough. And the title company just kind of sat on it and nothing happened. So make sure that it's enough to cover the amount of the policy. Special assessments. So these are special assessments from a governmental entity, like the city came in and put new sidewalks, or they put in a new storm drain system, or they put in new street lights, or they paved the streets, or whatever it is, and there's a special assessment against the property. It has nothing to do with HOA or condo assessments. So you want to indicate who's going to pay for those if they're still outstanding. So the first option is seller's going to pay everything up to closing, and then buyer's going to pay everything after closing. At line 185, the option is seller's going to pay everything at or before closing. In paragraph 10, these are 10 for 10 disclosures, 10 disclosures in paragraph 10. And the only fill in the blank is here at line 210. And this has to do with flood hazard insurance. And what this says is as buyer walks through this process, and if they determine that the property is ineligible, or if there are certain other conditions, then the buyer has the right to terminate the contract within 20 days after the effective date. My suggestion is always to make that time period coincide with the inspection period, so that you're doing all of the due diligence within the same time period, and you don't have that outlier that you have to keep track of. Just administratively, it makes sense, because it's so easy to miss these dates, right? If you have something that's a little bit weird, you don't want to miss those dates. All right, paragraph 12, this is the inspection period. It defaults to 15 days. I'm seeing inspection periods much shorter than that these days because of the way the market is. It really is up to what the parties are willing to accept. Buyers typically are going to want a longer period, sellers are going to want a shorter period. Whatever they can come to terms on, that's what goes there. It's important to remember at line 252, it says, in buyer's sole discretion, the property is not acceptable. That puts it all on the buyer to decide within that inspection period. If they don't want to buy the property, any reason or no reason at all, they can terminate. And the seller can't say anything about it. I've seen listing agents try to fight it. Well, you didn't do an inspection, or you have to give us the inspection report. No, we don't. We don't have to do anything. We just can just wake up one day and go, no, I don't think so, and terminate, right? Sole discretion. All right. So everything else is just kind of flyover country. There are no more blanks, not to say that it's not important, because paragraph 18, the standards, that's where your infrastructure is. That's where the meat of the contract is, really, because it tells us how everything else in the contract works. That's where we have our definitions, like how do we count time, right? What do we do with the leases? You see right here at paragraph F, time. What does force majeure mean? What's going to happen? What kind of deed are we going to get? All of those kinds of things are in paragraph 18 standards. And we talk about Ferpta again. And we're getting to it right here at paragraph V. There's another place where the contract talks about it. We also talk about it here. In previous versions of the contract, there was a separate rider for Ferpta issues. I still see people trying to use it. Don't ever use the Ferpta rider because it's wrong. The withholding in the Ferpta rider said up to 10% of the sale proceeds. The new withholding amount is 15%. So you want to make sure that you don't use that rider. All of the language for Ferpta is already included in the contract. You don't need anything additional. Paragraph 19 is very important. This is where we're going to mark all of the addenda that get included with the contract. And so if you look right here in the first column on the left, where it says I reserved, that was the old Ferpta addendum. If it says reserved here, that means you cannot use it with this contract. So don't ever use, well, you can't use I because it's not valid anymore, even though people still do it. But K and L, don't use it with the as is. Those are only for the standard contract. So you want to make sure you check each addendum that's going to be included, because look what it says at line 569. The following additional terms are included in the attached addenda or riders and incorporated into this contract. Those are magic words. They're words of incorporation. So what that means is that now is part of the contract. If you just have something attached to the contract and you don't have that incorporating language, then technically it's not part of the contract. And if you haven't checked it on here and it's attached, technically one party could argue that it's not part of the contract. We do it all the time, right? We just pretend it is. But if somebody really wanted to press the issue, they might be able to argue successfully that it's not part of the contract. This is also important because it could affect your effective date. So affect your effective date. If it's checked and it's not included with the contract, guess what? You don't have an effective date until you get it as part of the contract. An agent called me about that the other day. If it's not checked and it's not included, it doesn't affect your effective date because you haven't included it in the contract. So super important. You always want to make sure you check the right box and you then include it with the contract. We've already talked about additional terms and what you might put in there. Don't be creative. Use it for overflow of things that you are already going to be putting in the contract and filling in the blanks. Don't use it to write new language into the contract. because then you're getting really close to practicing law without a license. Don't use it to make up something that there's already an addendum for. I see a lot of agents write, this contract is subject to review by the seller's lawyer or the buyer's lawyer. Well, guess what? Review does not mean approve. We have an addendum that says approval by the lawyer. And that's what you should use if that's what you intend, because review just means I can read it, but I have no input on what happens, right? So words matter. Make sure you write the right words. And if there is already an addendum for it, then use the addendum. Line 589, this is seller counters the offer. So seller has a counter offer, boom, I'm going to check this. Maybe I'm just going to go back on this contract and change the terms, like I'm going to change the purchase price or the closing date or the inspection period. And then I'm going to initial, I seller, I'm going to initial, I'm going to send it to the buyer, buyer's going to initial, and we're all good. The next line is seller rejects. It's like, nope, don't want it at all. I'm going to reject it and send it back to you. So if you're talking to the buyer or the seller about this contract, you really want to start on this page and point out to them at line 592, this is intended to be a legally binding contract. If you don't understand it, go talk to your lawyer. And that's what they should do, right? We can't explain it to them. We can't tell them what it means. We can only tell them what it says. And then the next one is important. This has been approved by Florida Realtors and Florida Bar. So it's an approved form of contract, this one and the standard contract, both FAR bar contracts. Next one, 599 asterisk after the line number means you need to fill in the blank. So even if you're using the default time period, even if you're not paying additional fees for the seller in line in paragraph 9, you want to put something there. Don't leave any blanks blank. And then we want everybody to sign, all of the buyers, all of the sellers. If you need more signature blocks, you can put it down here, or you could attach another page. But you want to make sure everybody signs. And then you want to put who's representing whom. So the cooperating sales associate would go there and the name of their brokerage. The listing sales associate would go there and the name of their brokerage. And we have done it. Any questions? I know that was like, phew, but we did it. Any questions?
I can't think of any that I have.
Okay. Well, if you think of any later, let me know. I'm going to stop the share and I'm going to, okay, so let me announce again that I was, before we really started with the class, I was talking about a couple of networking platforms that I'm discovering recently in recent weeks. And one of them is Alignable. And another one is Happy Neighborhood Project. If anyone is interested in checking out Alignable, put your email address in the chat and I'll download it and I'll send you a link. You can check it out and let me know. But I've met a lot of really amazing people. I've gotten a lot of good connections that could lead to potential business. I mean, it's a great way to network. And the key is to join the groups. So anybody who's interested in that, quickly put your email in the chat and I'll be happy to send the link to you because I'm going to save the chat and download it before we end the call. So, okay, I'm going to do that now. If anybody feels later that you want to do that, just reach out to me and let me know and I'm happy to send it to you. And check out the Happy Neighborhood Project. It's pretty cool as well. Okay, and I'm going to put my email and my phone number. Okay, so you should have my contact information already, but if you don't, there it is. Feel free to reach out to me. whenever you have a question, or if you just want to talk about something, some issue, I'm happy to help you. If you have questions about the contracts or transaction, whatever it is. All right, well, thank you, everybody. This was fun. Did everybody enjoy it, or was I the only one?
Yes, thank you very much.
Thank you.
Awesome. Yeah, well, good. I'm happy to do it. I hope it was helpful to you. And is everybody on the forum on Facebook?
Yes.
Yes.
You should be. Mhm.
Okay, awesome. Yeah. So obviously, feel free to post questions there. If it's a more immediate issue, reach out to Murray or me directly, because we're not spending a lot of time in Facebook. So, all right. So let me save the chat. And sorry, my dog is barking. So, well, thank you again.
Thank you.
And
Sally.
I will see you next time.
Alrighty, bye.
Bye. Bye, everybody.
Bye.